Hello, everyone, and welcome to MSU FCU's Financial Education Seminar Series. We're so glad that you could join us this afternoon. These events are designed to give you practical tools and insights on a wide range of financial topics, things that truly matter in everyday life. Each seminar is led by a member of our financial education team or one of our trusted partners, like today, helping connect you to resources both here at the credit union and out in the community. We've got an exciting lineup of sessions planned throughout the year, and you can check them out anytime at msufcu.org/events. Today's program is being recorded, and you can rewatch or share it by going to our YouTube channel and then just search MSUFCU Seminar Series, and then you'll see a whole list of all of our recorded seminars there that you can rewatch or share. And then after the presentation today, after Melissa wraps up, we'll go ahead and move into the Q&A session. So you can go ahead and submit your questions as she goes through her presentation. There's a little Q&A function at the bottom of your Zoom screen, so you'll use that to submit questions. And then we'll go ahead and answer those once she wraps up at the end. I am Therese Bacon. I'm a financial educator here at MSU FCU. And today we have a wonderful guest returning with us again this year to talk about estate planning essentials. So please help me welcome Melissa K. Allen, attorney at law. Thanks for joining us to share all your expertise on this very important subject, Melissa. I know our attendees always get a lot out of your presentation, so thanks again for joining us. I'll go ahead and pass it over to you to introduce yourself to the audience, and then we can lead right into your presentation.
Hey, great. Thank you so much, Trace. I really appreciate that. And I'm happy to be back again. I really need to go through all my old calendars and figure out how long I've actually been doing presentations for MSUFCU. I think we might be going on 20 years now. So it's always great to work with such a wonderful financial institution. So we're going to start today by I'll tell you a little bit about myself, and my presentation usually lasts about 45 minutes, and then we'll have about 15 minutes at the end for questions. If you don't have time to ask your question, or we don't have time to answer it, if you'd like to email my office, I'll be giving all my contact information at the end of the seminar. You're welcome to do that. We're happy to answer questions if you need some clarification from what we're talking about. So as Teresa said, my name is Melissa Allen. My office is in DeWitt. The address is right there on the screen. And so if you're familiar with DeWitt and you are familiar with the Flapjack restaurant, which seems to be everybody is familiar with that here in DeWitt, my office is the building behind there. So it's kind of right off of Old 27. I have been practicing here in DeWitt for 30 years. This is my 30th year. So it's been wonderful. I love doing estate planning. This is the focus of my practice. So I do all the upfront planning and then the after death administration. And I really love this area of law because it's a really positive area of law. When people leave here and they've done their estate planning, they really feel good about doing it because they know they're doing something to help their families if they became incapacitated or when they pass away. So it's really a good thing. People feel good when they leave, and it makes me happy when they leave here and are feeling good. So as I mentioned, I've been in the DeWitt area for 30 years. I actually live in Bath, and I have two amazing children. My son actually just graduated from U of M in May, and he just moved to Boston last month to start his career at Ernst & Young, a division there. And so I'm super proud of him. And then my daughter is a junior at Grand Valley in the nursing program. And she's currently getting all A's there. So I'm really proud of her too. And then my husband and I still live in the Bath area, waiting for our children to come home now that we're empty nesters. So let's go through. We're going to talk about these topics today. So my goal today is that everyone who is listening will learn something new about estate planning. There are a lot of myths out there. I get a lot of people that come into my office and say, hey, this or that, and they've heard the wrong information from someone, or maybe a neighbor hasn't really understood something, or whomever they've spoken with. So the goal is that if you have a question, or you're kind of just exploring the topic of wills and trusts, I'm hopeful that after today, you'll get a clearer understanding of what these issues are. So we will be talking about wills, and that wills go through probate. We'll talk about the probate process. I'm also going to talk about the joint ownership of assets and why there are definite problems with that. And the main thing we'll be talking about are revocable living trusts, and I'll explain that to everybody. Hopefully, that my goal is always to be very easy terms, easy explaining things. So that should be hopefully helpful for everyone. And then I definitely want to spend some time on powers of attorneys also. Those are such important documents. I tell everyone, whether you have a will or a trust or nothing at all, you really should have powers of attorney. So we'll spend a little time talking about that. So, in talking about wills, so a lot of people, one of the myths that I hear a lot is a lot of people come into my office and they have a will already, or they say, I want a will. And the idea is that they think that because they have something in writing, that's what avoids going through the court system, the probate court system. But in actuality, that's incorrect. All wills do go through the court system. So if you have a will, or you have nothing at all, probate is required on your estate. So people will maybe want to explore a different option if they want to avoid the court process. But let me tell you a little bit about what probate involves. It's, some people think it's, this horrible process, and some people don't really understand what going through the court system is. So going through probate means an estate is opened with the probate court. Once that estate is opened with the probate court, it's a minimum of 5 months for that estate before it can get closed. But I have probate estate cases that have been open 2 or 3 years. So it really depends on the assets that are in the probate estate, how long it'll take. It depends on the beneficiaries, how well they get along, and that type of thing. But it is a minimum of 5 months. During this process, there's a lot of forms that are required by the probate court, and they have definite deadlines of when they want things due, and they have definite ways how they want the forms completed. So during this process, there's all the paperwork that's required to be filed by the probate court. It's a public record then at that point. So a lot of people don't really think about that their estate is public record. And a lot of my clients don't like that idea. They don't like the idea of having somebody being able to see what they owned when they passed away. The other thing about probate that a lot of people don't really understand is that once a probate estate is opened, all of your legal heirs get copies of all the probate documents, whether they are an actual beneficiary in the will or not. So there are a lot of families that have situations where they don't want a certain child to inherit anything, or maybe a cousin or a niece or nephew or whatever the case is. And so they think, well, I just won't provide for them in my will. Well, that doesn't matter because your legal heir is kind of the next in line of your bloodline. If you have children, if one of your kids has predeceased you, then their children is considered a legal heir. If you don't have children, it would be parents and then siblings and then goes down. So it kind of goes down the line of whoever is alive. So people often have to get notice of things and they're not inheriting anything because your will might say they don't get to inherit anything. And a lot of my clients don't like the idea of other family members getting copies of documentation because sometimes it can get confusing. So there's the paperwork involved, there's the kind of the time constraints involved as far as deadlines for the documentation. There's the public aspect of probate, and the fact that there's this notification to the legal heirs. So those are some issues that a lot of my clients don't like. Another issue that people ask me about all the time is how much does it cost to go through probate? So if you look at these minimum probate costs, you can kind of in your mind think of the value of your estate, and then you can go over to the minimum total cost. So the two costs that I have listed here are the inventory fee and the filing fee. The inventory fee is the actual fee that's charged by the probate court to process the estate. And you can see the more money in the estate, the higher that fee becomes. That's kind of a percentage of your estate, so to speak. And then there's a filing fee, which right now is $188. So, and that goes up, a couple dollars every year or every few years. So these are just the two minimum fees that I can tell everyone about. So I want everybody to kind of focus on the word minimum there, because I don't want anybody to look at this and think, oh, that's all it costs. That's not so bad. These are just the two fees that I can definitively tell you that the court charges. There are other fees involved. So usually what I tell people on the minimum total cost line is if you add $3,000 to $4,000 to that, that will give you a better ballpark of what it would actually cost your estate to go through probate. And I'm giving you a ballpark because it's hard to tell. It's hard to tell some of these other fees. So, for example, every time a letter of authority is required by the court, there's a charge. You get those attorneys in there and they charge a fee. So, a lot of that is kind of dependent on how the estate is progressing and what the fees would be. So, that can kind of give you a good feel for what it would cost your estate to go through probate. So a lot of people say, oh, they think half of their estate will go through probate or go to the probate courts. And that's not the case. But usually kind of a good rule of thumb that people in my field say to people is around 8 to 10% is kind of a good ballpark to figure out what it would actually cost your estate to go through probate if that's a concern of yours. So most of my clients are a little more worried about having the extra work for their children to have to do than they are so much about how much it costs. But that can give you a good ballpark if you're thinking of that. So some people say to me, "Oh, I don't want my kids to have to go through probate or my family to have to go through probate. Why don't I just put them joint on my assets and then it automatically is theirs?" And for the most part, that's a true statement. If you put somebody joint on one of your assets and you pass away, presumably it'll pass right to them. So there's a couple instances where there's some other issues that would be involved with that, but that could pass to them. The problem with that, though, is when you put somebody joint on one of your assets, legally that's half their asset. So if they have creditor problems or they have marital problems or they get into a car accident and they get sued, then they can attach to your assets because you have this person joint on your accounts. A lot of people don't like that. I mean, that's a risk factor. I had a client who came into my office. I'll never forget her. This was several years ago now. And she came in, she said, I need a trust right away. And she was quite adamant. And I said, whoa, what happened? And she said, well, I had my daughter joint on a CD at my bank and she got a divorce. And my ex son-in-law got her half of that CD. So essentially, he got a quarter of her CD, this woman's CD, just because her daughter was joined on the CD, and she was not happy about that. So, which I couldn't blame her in the least bit. So, but she wasn't aware of that. She didn't realize that that would be considered half of her daughter's asset legally. So that's something really important to think about. I see people all the time come in that have large accounts that will have a child join on the account, and they just don't realize the legal ramifications of that. And I often tell clients, a lot of my clients will come in and say, well, I just want my child join on my checking account, for example. So if I, go to Florida or something, they can write a check. And I always tell them that's fine if it's a small account. I wouldn't worry about that. But if anything that's worth something or a bigger account, you certainly wouldn't want to have that jeopardized by having somebody join on there. So that's kind of the legal side of having someone join in an account. There's a tax issue also that a lot of people aren't aware of. So I'll use real estate as an example because I do see this quite frequently. I'll have people come into my office and they'll have a child join on their deed, or they'll have a brother or a sister. What happens with that is when you put somebody joint on the deed to your property, and then they sell that property when you've passed away, they will have to pay capital gains on that. So here's an example of this. So let's say my dad puts me joint on his deed today and he passes away tomorrow. And let's say that he paid $75,000 for his house. And actually my dad bought the house he lives in now in like 1974, I'd say. So it was, very small amount. But let's say it was 75,000 back then, and then he passes away tomorrow. And I sell the home for $200,000 because that's what it's worth now when he passes away. I would have to pay capital gains on the difference between what he paid for it back when he purchased it and what it's worth when he passed away, assuming I sell it for what it's worth when he passed away. So in my example, I would have to pay capital gains on that $125,000 difference, which is roughly 19,000. I'm rounding up here at the current kind of the average tax rate for capital gains right now. So this number a lot of times can be quite large. You know, I kind of purposely put a small capital gains number on there because I've seen instances where people have had to pay a lot of in capital gains. I had a client once who came in, her dad had bought a little one-bedroom shack on Houghton Lake, 60 some years ago. He personally built it up into a nice 3-bedroom home. Someone told him, she was an only child, so someone said, oh, just put her joint on the deed. So he did. When he passed away, she sold the house. She came to me after the fact and she said, I sold the house. I assumed I could. I'm assuming it was legal or somebody wouldn't let me sell it. And I said, well, of course, you legally could do that. But I said, you need to talk to a CPA about the capital gains you'll have to pay. And I could pretty much hear her screaming from across the hall. At the time, there was a CPA across my hall, and she ended up having to pay about $150,000 in capital gains because that property had appreciated so much in value. And this man didn't keep any of his receipts on anything because it had been so many years. And so she had to pay capital gains on that difference just because he put her joint on the deed. So I see this a lot with clients. They come in and they'll have a child join on the deed, and that child would have to pay a lot of money if they were still joined on the deed. So it's always better to have your child, and again, and I'm using child as an example. This could be any of your beneficiaries, whether it's a niece, nephew, brother, sister, whoever your beneficiary is. So here's an example. So if my dad would have not put me joint on his real estate and I inherited it when he passed away, and it was worth $200,000 when he passed away, and I sold it for 200,000, I wouldn't have paid any capital gains. So in this situation with this woman who came in, if she would have inherited her dad's property, she wouldn't have had to pay that money. So again, the idea isn't to try to, uh, not pay taxes, but I'm sure that this man wanted his daughter to inherit that and not have to pay taxes on that. Every single one of my clients that has come in always wants their family to inherit as much as possible and not have taxes paid on that. So if you have a child joint on your deed, or if you're watching this for your parents and you know your joint on their deed, you should probably investigate not having that be the case anymore, so you don't have to pay a big capital gain on that when they're gone. So we've talked about probate. We've talked about joint ownership of assets. If none of this sounds good to you, then let's talk about revocable living trust. So that's what we'll spend a little bit more time on. That, in my opinion, is the best way for the majority of people to avoid everything we've talked about. So let's talk about what a living trust is, because sometimes people get different information about that. What a living trust is, or a revocable living trust, or a trust, those are all interchangeable terms. But what a revocable living trust is that it's still your asset. You can still control everything while you're alive. You can make changes to your documents while you're alive. So it's actually a 2-step process. And the second step I see a lot of people miss if they've gone to an attorney who does not specialize in estate planning. So if you already have a trust, don't fall asleep yet or sign off yet, because the second step I see missed quite often. So the first step is the kind of the obvious one, is you actually set up your documents. So a trust is actually kind of nice because you can get really creative in your trust also on inheritances. So for example, in a living trust, you can say who you want your beneficiaries to be. If you have minor beneficiaries, you can state that they don't get their inheritance when they're 18, because, quite honestly, at 18, that's pretty young age to get an inheritance. you can pick a later age, 25, 30, those are popular ages. I had a client who came in once and he said 65. He didn't want his kids to inherit until they were 65. He wanted them to have a retirement. So everybody has different goals in mind of when they think their kids would be ready for an inheritance. And so a trust is really kind of a great way to do that. Once you've created these documents, you've named your beneficiaries, you've put restrictions in there if you want, as far as ages, that type of thing. You name your trustee. So your trustee or your successor trustee is the person who administers your estate when you're gone. You can have more than one trustee also. You can have two. Don't do more than two because sometimes that's just too many cooks in the kitchen. I have a lot of clients that ask me if they can have two of their kids be co-trustees. And I always say that's fine as long as they get along. If they don't get along, don't name them as co-trustees because that will not help them get along any better. But you can do that. You can have co-trustees. That's not a problem. Again, as long as they get along. I did a in-person presentation a few years ago, and it kind of audience interactive, and one of the people had asked at the end, and they said, "Can I name both our kids?" And I said, "Well, you can if you want." And she said yes, she wanted to, and he said no way, kind of right at the same time. And I was happy they were kind of in the back of the room because they kind of argued a little bit the whole rest of the presentation. It was kind of funny, but so yeah, that's something that you'd want to think about ahead of time before you talk to your estate planning attorney. So these are things that go in the document itself. The second step is actually the important part of avoiding probate. And I have it right here. It's called funding your trust. So any asset that you own that does not have a beneficiary has to be retitled into the name of your trust to avoid probate. So examples of this would be your home. A lot of brokerage accounts and stock accounts, you can't have a beneficiary. A lot of banks, you can't have a beneficiary. Any real estate as far as timeshares, even a lot of times people think about that or forget about those. So these are examples of assets that don't have beneficiaries on them. You want to make sure those are retitled into the name of your trust. That's what avoids probate. So it's kind of like the way I look at a trust is like an empty bucket. You need to put things in the bucket for it to work. So when you get a trust done, you'd want to have a deed done to all of your real estate, transferring that into your trust. Same thing with your brokerage accounts, CDs, bank accounts, that type of thing. So that doesn't change anything while you're alive. You can still spend it all, save it all, do whatever you want. But what happens is when you pass away, whomever you've named as your successor trustee can immediately access all of these assets that are in the name of the trust. They don't have to file anything at all with the probate court. So they can immediately contact your broker. They can immediately get into the home to start divvying up the personal property and get it ready for sale or to, transfer it to somebody if that's in your trust. So it's a really easy transfer from you to your successor trustee to be able to step right into your shoes once you're gone. That's the thing about a living trust that everybody likes. That's why I'm a big living trust advocate because it is easier on your family. And anytime you can make things easier on your family after a death, that helps with the family unity, I think. People seem to get along better when there's a trust than versus going through probate. And my thought on that is that because there's a judge appointed to a probate estate, I feel like that makes people a little more anxious or maybe makes them feel like they could argue more. Trusts are a little more streamlined because of that. And then they're also private. So no one gets a copy of your trust documents except any of the people that are named as beneficiaries. That's another nice bonus of a trust is that a lot of people don't want different family members involved or don't want different family members or other people or the public for that matter to be able to access their documents. So that's another appeal to having a trust is having it be private. And so it's really important you do this trust funding because that's what avoids the probate process. And so a lot of people ask me, okay, you're talking about assets that don't have beneficiaries? What about assets that do have beneficiaries? And so that's something you'll want to talk about with your estate planning attorney. Depending on the asset, you might also want to change the beneficiary or the contingent beneficiary to your trust. So for example, if you're married, most people would still have their spouse as a primary beneficiary, but it's nice, for example, on life insurance to have your trust be the contingent beneficiary. My philosophy is the more money in your trust to help with expenses, the easier it is for your successor trustee. So they'll have access to more money. So if it, for example, if it's funded by a life insurance policy, if it takes a year to sell your house, they will then have more money to be able to pay for property taxes, insurance, utilities, that type of thing. So the more money that they can have in the trust, the better. A lot of times people come to me and they say, "Oh, I'm just going to make my kids beneficiaries on everything. I don't need a trust." Well, that's okay, but that means all that money is paid out to these people. So when the house has to be sold and when the property taxes are due, that means all the beneficiaries have to pitch in money. They're not legally obligated to, but now everybody's kind of gifting money back and forth, and it kind of can create an accounting nightmare, depending on the situation. So if you want to have it easier for your family members to administer your estate, a trust is really the way to go. Making sure there is money in the trust for expenses makes it so much easier for your administrator. So that's definitely something to talk about with your estate planning attorney. And sometimes people say to me, "Oh, well, I was told I don't have enough money for a trust." And I always kind of laugh because anything above the current level for this year, for 2025, is $50,000. So anything that you have above $50,000 has to go through probate. So usually, right when people own a home, they're at the $50,000 mark. So a probate estate would be required. So don't fall into that trap and thinking that you have to have millions of dollars to have a trust to have to if your goal is you want to avoid probate, because anything above $50,000 goes through probate. So I do feel it's as easy as saying, do you want your estate to avoid probate or not? It doesn't need to be complicated thinking about getting a trust. If you want it to be easier for your family members and you don't want them to go through probate court, then a trust really is an option you should be exploring. And I think it's really honestly as easy as that. And so if you are exploring a trust option, just make sure you go to an attorney who specializes in this. From start to finish, it should be a super easy process. It should go very smoothly if you go to an attorney who specializes in this. So from start to finish, you should be done in a couple of weeks. It really isn't that time consuming as long as you go to someone who specializes in this. And it's really important to get done. And it's definitely something important to explore if you don't want your estate going through probate. So now we've talked about probate, we've talked about joint assets, we've talked about trusts. So we've talked about all this, death stuff. So now we're going to talk about incapacity next, another fun topic. So powers of attorneys. These are such important documents. I tell people this all the time. I think everybody should have these. So there are two different types of powers of attorneys. One is for healthcare decisions and one is for finances. They can go into effect either immediately or only if you're considered incompetent or disabled by one or two physicians. So you can have that written in there however you want. A lot of my quite elderly clients will have them effective immediately so that their kids can help them with their banking and their accessing and paying bills and that type of thing immediately. But you can certainly have it effective only in the event that you become disabled and you can't make your own decisions. And that's when I think it's really important, because if you have a sudden stroke or get dementia or something and you don't have these in place, then your family has to go to court and get appointed as a guardian and conservator, and it's very time consuming and it's very expensive. But these documents are very easy to get. They're relatively inexpensive compared to having to go to court. The healthcare power of attorney is exactly what it says. It's just for healthcare decisions. So it covers everything healthcare related. that document should have the HIPAA waivers built right in. So you should have it, whomever you've named as your patient advocate should be able to access all of your medical records. And that's the document where you put your preferences on life support. So if you don't want to be on life support, if you're in some kind of irreversible coma, or something along those lines, you need to have a healthcare power of attorney saying you want to be taken off of life support. So that's one power of attorney. The other power of attorney is for finances. So this is a really important document also because this covers anything you could do on a daily basis, but if you can't because you're incapacitated, you need to have somebody legally appointed to do it for you. So this covers everything. This covers anything to do with your cars, your real estate, your banking, paying bills, signing tax returns. That's a biggie, being able to deal with Social Security and the government, being able to access IRAs and 401ks. So even as a spouse, because a lot of times people say to me, "Oh, we're joined on everything." You can't be joined on a 401k or life insurance. Well, I think there are probably some joint life insurance policies, but not necessarily the kind that I'm talking about. But 401ks, IRAs, those type of things, you can't be joined on. You can only be a beneficiary. So if you need to access your spouse's accounts, if they became disabled and you needed it for medical expenses, for example, you would need a financial power of attorney to do that. So these are really important documents because you're still alive. So it's really important that you have somebody in place to be able to make your decisions for you if you can't make them for yourself. So those are really important documents also. And a lot of times people will kind of wonder who should they appoint for these. And in my opinion, if you have somebody for the healthcare power of attorney that does have um, medical background, any kind of medical background, I think they're a good choice to appoint on the healthcare power of attorney, just because they would be kind of maybe more familiar with the medical jargon. So that's often what I'll recommend to people if they have someone. A lot of times people like to name someone that's close by because if they feel like there's a medical emergency, that person can get to the hospital quicker. Although, healthcare providers would certainly discuss issues on the phone with your patient advocate. So that doesn't have to be a determining factor. As far as the power of attorney for finances is concerned, that again doesn't have to have somebody in close proximity. A lot of times people say that to me, well, I think I should name my child that's the closest. I think so many financial institutions now, you can sign documents online, DocuSign, or do things online. So I don't think that has to be a determining factor either. So if you have somebody that's, good with numbers or is well organized or something, I think those are good choices for a financial power of attorney. So these are just some things to think about, but you should definitely, I think everybody should have these. The one thing I do want to point out about the financial power of attorney, and this is really important, last year in 2024, so in July, as a matter of fact, of 2024, they completely changed the statutes on financial powers of attorneys. So if you have a power of attorney prior to that date, you really should talk to your estate planning attorney. I'm recommending to all my clients that they get new ones prepared that will be under the new statutes, because the new statutes actually were put into place to protect people better, and have financial institutions kind of put them more responsible for honoring powers of attorneys that are validly drawn up and meet the statutory requirements. So it's better for you as an individual to have an updated power of attorney, just so that your person you've named doesn't run into any financial difficulties. If you become incapacitated and then they try to use an old power of attorney and then they have problems, it's just better to be proactive about it. So that is everything that I want to talk about. We kind of got through that pretty quickly. We will have time for questions, but what I did want to let everyone else know too is if you would like to contact our office, Emailing would be better. We do have some documents that kind of our general estate planning information that if you'd like to receive it, you can email our office at melissakallen@aol.com. I know it's still AOL, but I hate to change it after all these years. I have so many clients that are so used to my email. After 30 years, you kind of hate to rock the boat a little bit. Or if you want to get on my website, I kind of have some of the information I talked about today. There's some video or some vocal chatting on this again too. But email us. We're happy to send you the information packet. Or if you want to call the office, that's fine too. Emails work out well because then we can email it back to you and we'll already have your return email address. But I appreciate everybody coming today and, well, not really coming, but joining us virtually, I guess I should say. And thank you, Therese, for always, MSUFCU always does such a fantastic job of really caring about their well, I don't know if are they
Members.
called clients? I don't know if
Members.
you call
Yeah.
but there you go. Yeah. So, and I
Yeah.
think that's a fantastic thing. So
Yeah.
at this point, I think we can go for questions.
Yeah, sure.
If,
Nothing's come through yet, so we still have everyone online though. So I know sometimes it takes people a couple minutes to write out their questions, so we can just
okay.
hang out here for a few minutes. But definitely,
Please don't ask me to sing and dance or anything to entertain people because that's not happening.
No, never. Um, but yes, feel free to reach out to Melissa or reach out to me if you do want more contact information. I'll feel free to get that to you. And I guess in the meantime, while everyone's if you are typing questions, I'll let you know about some upcoming webinars that we have for seminar series. So next webinars are we're doing one on budgeting and shopping tips for the holidays. So I feel like that one's going to be pretty important this year, especially with the economy the way it is. So that is Wednesday. Next Wednesday, November 12th at 6 p.m. So that's an evening one. And then on Tuesday, November 18th, we have our friends from Silver. So a lot of you probably have heard of the Retirement Simplified platform that we promote here at MSUFCU. But the CEO of Silver will be here to talk about year-end tax tips. And that's another noon session. So if you do like this midday session, you can definitely join us for that Tuesday, November 18th at noon. So, so we did have one question come through here. So I know you might not be able to answer this exactly right, but maybe you can give a roundabout answer. But what is the typical cost of setting up a revocable trust?
Well, a typical cost, I mean, it really depends on where you go. If you go to a big firm, you'll be paying more because they have more overhead. So I guess I couldn't really tell you what would be considered a typical cost. I know personally my information, I have it all broken down. I'm very transparent about costs. If you want to email to get my personal cost information, I know I did a consulting uh, what do you want to call it? Analysis. I hired a consulting group in this spring, so I can tell you that I'm definitely in the average. So I'm not too high and I'm not too low because I had them do samples from all across mid-Michigan. So if you want to get my personal information, you can go ahead and do that.
Sounds good. All right. So another couple questions that came through. Can your spouse be chosen as your POA for healthcare or finance, or should it be someone else?
Most people do pick their spouse, but sometimes they don't. So it doesn't have to be your spouse. So yes, normally now how I do my powers of attorneys, and again, everybody could be different, but I always have a first choice and a second choice. So most of my clients pick their spouse as their first choice, and then we'll have maybe a child or a brother or sister or somebody as a backup choice. So that way, if your spouse has predeceased you, or maybe if they're also incapacitated, then your backup choice can automatically make your decisions for you.
That's great. Was actually a question that I was going to pose to you. Because I know like me and my husband set these up years ago, but then I'm like, okay, I need to pull these out and actually look at them and see if they're set up correctly or if anything's changed. So,
Yeah, no,
yeah,
that's a
for
good
sure.
idea.
So you can have a contingent just on the original
Yeah,
document of your POA. Okay, sounds
exactly.
good.
Yep, it's allowed. And then I always encourage my clients to do that too. That way you
Yeah,
don't have to amend it. And then
right,
the other thing too, sometimes people will say to me, "Oh, I'll just amend it." Well, if you're incapacitated, you can't amend it. So
right.
it's always good
Yeah,
to have contingencies built into your documents.
for sure. And then if you do have beneficiaries on your house bank account and 401k, which is all I have of value, is it okay not to have a trust or will?
Well, you should at a minimum, I always tell everybody, at a minimum, you should have a will because something could have to go through probate and you would need to say who you would want your beneficiaries to be and who you'd want your administrator to be. So let me give you a prime example. I had a client who she was unfortunately killed in a car accident. Well, then she had insurance proceeds that had to go through probate. So, and they were pretty substantial. So, you know, it was important that she had a will to be able to say who her beneficiaries would be. And again, sometimes a trust is even the way to go, depending on the circumstances with children, how many kids you have, and that type of thing. But at a minimum, yes, a will is really important to have.
Okay. And then is your someone was asking about like is there a fee for the initial consultation with you, or is that like a cost
So,
visit? How
so
does that work?
I don't necessarily, well, if there, yeah, so I don't, initial consultation is, maybe a little bit of a misnomer. I do charge for consultations. As far as my trusts are concerned, the consultations are built into the trust package price. So it's not a separate fee for the consultation if you're getting a trust, but if you're just coming in to, you know, chit chat and ask questions, then yes, there would be a fee for that.
Hmm. You know, and I've heard of people, like downloading stuff off documents off the internet or something and think that they have all their stuff set up. So is that something that could actually work for people, or I mean, you probably
Oh,
say
that's so
no, but
terrifying to
yeah,
me. That's
yes,
so
okay,
scary.
me
Oh
too.
my
Yeah.
gosh. No, it's, you know, and I've had people ask me that before, and I don't, you know, I know I'm going to be perfectly honest with you. To me, that's so scary because this is such an important issue. These are such important documents.
Yeah.
Why would you want to take the chance of having them be wrong? I've had situations where people have done that and the documents are completely not what they really wanted. Or even if they've gone to a general practice attorney, I've had lots of
Hmm.
problems and lots of mistakes. A lot of the free attorneys that people get through like GM and stuff, I've seen a lot of errors with that even.
Hmm.
My thought is that if, you know, for example, like I don't know anything about cars. I'm not going to try to fix my own car
Yeah.
because that's too important to have a safe car.
Right.
So no, I don't think that's a good idea. I even for myself for other areas of law that I don't do, I hire other attorneys. You know, I'm not
Yeah.
going to try to do it on my own because
Right.
I don't know all the ins and outs
Right.
and you know, and after 30 years of doing this, I think I've pretty much seen everything and I know all the ins and outs.
Right. Yeah, yeah. I know how scary it would be, and then you don't even realize what is wrong in those documents or like were they even for your state? I'm sure there's different laws per the
Oh
states and
yeah.
counties and all those
Uh,
things. So, yeah,
Yes.
yeah. So,
Yes, definitely.
yep. So always good to get an expert, when you're dealing with these really important issues.
Yes.
So, okay, well, great. I think that answers all the questions that had come through. So once again, you can contact Melissa's firm at melissakallen.net, or email her for those other documents that she can, or the other information that she can send you directly. And she'd be happy to look into whatever you guys are interested in as far as estate planning goes. So thank you again for being with us, Melissa. As you close out of the Zoom this afternoon, there will be a short survey that pops up. It's just a few questions. So we like to get your feedback. Obviously, Melissa always gets great feedback. That's why we keep asking her back after 30 years, right? Um,
Well,
but yeah,
that's
if you
good.
can,
I'm glad to hear that.
yes. So if you can take that survey, we'd really appreciate it, everyone. And we hope to see you all at a seminar series event soon. So thanks again for being with us, Melissa, and we'll chat with you soon.
Thank you so very much.
Okay, have a good afternoon.
You too.
All
Bye-bye.
right, bye.